just trying to help people and keep the weekend clear, so you won't have to worry about this in the week. I know Saturday is the day when I usually am thinking about these things. So Ahmed.
Yeah, Professor, on how do you want the homework to be, in essay format or something similar to the bibliography?
No, this should be in essay format.
How many pages?
Does anyone know? Paul, you were going to say 20 to 25, or no? Why don't we say between 4 and 6?
All right. Thank you, Professor.
Good. And let's see. Any other questions? And then actually, we do have Abigail Verfeurth is going to give a presentation. And for those who are leading our discussion on Wednesday, I sent one of your team a number of things that you can look at. You know, thinking, again, I realize I didn't pick out things for this particular group to read. So we are looking at essentially the Jefferson administration and trying to answer this question about whether Jefferson was, once he was in power, did he abide by what he had been preaching, or was it something different? So you can look at a number of issues, you know, the purchase of Louisiana, the impeachment of judges. I don't know if that's something he would not have advocated when he was a small government guy. The embargo, which we'll be talking about in a bit, the trial of Aaron Burr. And in fact, there's a, you know, once upon a time, scholars did spend a lot of time with Jefferson, and I think scholars still will, because he's an interesting character for a lot of reasons. And one eminent scholar has said that over the course of American history, anyone who has bet against Thomas Jefferson has lost. And it's a long history we are talking about. So Jefferson has had his ups and downs in the public mind. In fact, 70 years ago, one of the Merle Peterson wrote a book called The Jefferson Image in the American Mind that talked about how Jefferson's image had fluctuated quite significantly over time. And that was before any of us here was born, that scholars were talking about the fluctuation of Jefferson's image. So I apologize for those of you who already hate Jefferson because you love Hamilton, that now I'm making us spend all of this time with him. But I suspect that Jefferson will remain important in the American mind. And so that's just something to think about. And so I did send one member, I sent, I believe, Tessa a number of things to look at, and she can share them with the others, thinking about the different issues in which, you know, you have Jefferson and Madison arguing for a certain conception of power, and then what happens when they get into power. And is this significant? I'm not just saying, you know, maybe they were just blatant hypocrites, or maybe anyone in power has to confront limitations and possibilities, and what legacy do they leave? Or I guess who lives, who dies, who tells your story would be another way of putting it. So that's where we are. I know now I am just starting to ramble. And are there any other questions on this specifically? What the group is doing on Wednesday, when we'll all be talking about Jefferson. Maybe I should share these things with everyone so we all can read about, you know, the Jefferson administration, and then have a better discussion or not. Okay, so I will share those with the rest of you, and I apologize for not putting more on the syllabus, anticipating that I wouldn't get this far. We wouldn't get this far as a class, but this is a better group than I'm used to, or than I was anticipating. So, okay, let's see. Now, Abigail is going to share with us a research project she has been working on, so I will turn it over to you.
All right, let me just share my screen here. Okay. All right, so I was working this semester on a project, like an honors contract, about the constitutional rights of women. Okay, here we go. Here we go. A little table of contents. I'll be talking about Abigail Adams in early America, women's relationship to citizenship, jury service, military service, and taxation. A little bit of an introduction. Women's rights and opportunities in the United States have come a long way from being seen as their husband's property to being the vice president of the United States. So now we're going to get into early America and Abigail Adams, an introduction to coverture and the early fight for equality. So what is coverture? It's a legal principle that has its roots in English common law that colonists brought with them to the colonies. And it's an idea that women are second-class citizens and causes their citizenship and civic identity to be filtered through her husband's civic identity. So Abigail Smith and John Adams, as we know, First Lady and Second President of the United States. So here we are with one of the most popular letters, I would say. Abigail Adams wrote to John Adams on March 31st, 1776. And this is where the Remember the Ladies line comes from. And also the line we talked about in the first day of class, the all men would be tyrants if they could. In this letter, Abigail says, if particular care and attention is not paid to the ladies, we are determined to foment a rebellion, and we will not hold ourselves bound by any laws in which we have no voice or representation. And John got back to her rather sarcastically, kind of brushing off her request. And he said, depend on it, we know better than to repeal our masculine systems, for they are in full force. And by saying this, he is saying that government and the public sphere is inherently a masculine thing and excluding women from this. And later on in this letter, he said that if women were to enter the public sphere, government would be completely subjected to the despotism of the petticoat. So Abigail Adams reached out to her friend, Mercy Otis Warren, who, women at the time were not formally educated. Mercy Otis Warren, Abigail Adams, turned to their families' libraries to educate themselves on various topics. And in this letter, Abigail wrote to her, complaining about John's response, about how he wasn't really listening to her. And she also called upon her friend to petition Congress if they were to not give women the right to enter the political sphere. James Otis Jr., he was also arguing for women's rights at the time. He was arguing that there are plenty of merchant women who are in the public sphere and make a life for themselves. So why can't all women enter the public sphere? There is also an anonymous voice who wrote under the name Sally Tickle in a New York publication. And this voice said, consider yourselves as entitled to a suffrage and possessive influence in the administration of the great family of the public, take part in momentous affairs of community, in which province by liberal endowments he granted you in mind and person. This person was arguing that the administration at the time should include women in the public sphere. Women in the social contract. So we know that at the time we were looking at making government a social contract, but at the time, what was going on is a couple would marry, the woman would give up her civic identity, her identity would be filtered through her husband, and then her husband becomes the primary executive over her body and her decisions. So if women would transfer their civic identity, she then becomes deprived of her American right to life, liberty, and property, and then bars her from entering private contracts. So the question became, after a woman marries and she cannot hold or enter a private contract, how could she enter the social one? And then with this new social contract on the table, many women were asking, including Abigail Adams, is the only free choice of a woman whom to marry? So Abigail wrote this question to John again, and in this letter she said, in the freest of countries, our property is subject to control and the disposal of our partners to whom the laws have given sovereign authority, deprived us of a voice of legislation, obliged to submit to us the laws that are imposed on us. It is not sufficient to make us indifferent to the public welfare. She was not thrilled that after the Revolutionary War, women were still not allowed to enter, despite all the radical political thought about social contracts and equality that was going on. Theodore Sedgwick, who is a relatively conservative Federalist and a supporter of the American Revolution, believed the state could not possibly have tried to recruit women. There was nothing they could contribute to the rebellion. So at this point in time, they were really not interested in having women enter the public sphere. And as time goes on, obviously we are allowed to, but at the time of early America, it was not looking up. So now like talking on to like citizenship and marriage. So in 1822, a judge from Kentucky ruled that citizenship things like laws, regulations do include married women, and that, but he did get outvoted on this decision in the panel of judges. The majority voted in favor of classifying women among infants because they were dependent on adult men. Through these men, they enjoy the rights and privileges that go with United States citizenship. This would prove Abigail Adams to be correct, that the only choice a woman has is whom she wants to marry. Now like the question becomes with citizenship, what about if a woman were to marry a foreigner? Another thing that's important to when talking about citizenship is the doctrine of marital unity. And it's another idea that holds roots in English common law. And it's made so when applied to like the American sense, it's that if an American woman were to marry a man and his citizenship is of another country, she has to assume the citizenship of her husband. At this time, then a woman may become stateless if this were to happen to her. And so there's some legislation here. So the Naturalization Act of 1855 says children born outside of the United States will be granted citizenship if their father was a United States citizen. This also made it so that immigrant women would be granted United States citizenship if she were to marry an American man. This is also the first time on paper that women were considered to be citizens. Any woman who might lawfully be naturalized under existing laws, the existing law here being the Naturalization Act of 1790, if she married or shall be married to a citizen of the United States, she shall be deemed to be taken as an American citizen. And then in 1866, the passage and ratification of the 14th Amendment came with a guarantee of citizenship for all persons born or naturalized in the United States. And this is really important because the verbiage of persons extended citizenship by birth to women. However, federal and state laws excluded Asian people from gaining United States citizenship under the 14th Amendment. And then the Expiration Act of 1907 mandated that any American woman who marries a foreigner shall take the nationality of her husband. This caused a lot of problems, especially during times of war. Like, for example, if an American woman were to marry a German citizen during the time of war, the American-born woman would then have to take German citizenship, immediately lose her status as an American, and then at that point have to face potentially being declared an enemy of the United States. There is some examples of women who did lose their citizenship to marrying foreign men. In 1874, Ellen Wenshaw Grant, President Ulysses S. Grant's daughter, married an English man and then went abroad to live with him. Because of this, she lost United States citizenship. She was not able to get it back until 1898, and it was through a special resolution through the House of Representatives called House Joint Resolution number 283. And then Ethel Mackenzie was born in California, married Gordon Mackenzie, who was a British subject in 1909. She was also very active in the suffrage movement, and she was working in San Francisco at a voter registration drive. And in 1911, she tried to register herself to vote, and her application was denied by the Board of Elections Commissions, not because she was a woman, but because she was a British subject. Upon her marriage with her husband, Ethel Mackenzie believed that Congress had overstepped its authority by passing the Expiration Act and took her case to the Supreme Court. In 1915, the Supreme Court ruled that Ethel Mackenzie had in fact ceased to be a citizen by marriage on the basis of the principle of marital unity. And then some more legislation we have. The Cable Act of 1922, also known as the Married Women's Independent Nationality Act, stated that the right of a person to become a naturalized citizen shall not be denied to a person on the account of sex because she is a married woman. However, this did include men who married American women from China or Japan. And then it was not until the Naturalization Act of 1934 that both parents, father and mother, could pass birthright citizenship to their children. And then it was not until the Naturalization Act of 1940 that children born out of wedlock could inherit their father's citizenship status. So now moving on to jury service. If the right to a trial by jury is in the Bill of Rights, why were women not allowed to serve on juries? Jury service is a pretty uniquely American thing. Other places around the world leave the trial decisions made completely by a judge or other like legal scholars. And then early on, William Blackstone, who many American lawyers referred to for legal guidance in early America, wrote on his reflections on common law that women fell into a class of people that could not serve on juries because they suffer from a defect of sex. So then in Strotter v. West Virginia in 1880, it is based on a West Virginian law from 1879 that stated only white people may serve on juries. An African-American man was brought to trial and the jury was completely white. The Supreme Court ruled that a state may prescribe qualifications for its jurors and doing so make discrimination. It may confine the selection to males, freeholders, to citizens, to persons white, to persons of certain ages, or to persons having certain qualifications. And by qualifications, they mean like job qualifications or educational ones. However, out of all the groups that exclusion was considered to be constitutional, women were the only ones who could not change their faults. People can get older, people can gain property, people can become a citizen, people can gain educational and job experiences. However, like race, sex is not easily changed. However, as more states allowed women to serve on juries, the concern was raised that if women were summoned for jury service or jury duty, they would not be able to maintain a home, and others believed that women simply did not belong in a courtroom. On the path of jury service, the road to it took two paths. In the 1970s, the right to jury service went one of two ways. One of the ways was cases testing the constitutionality of excluding people from jury service based on race, and the other one was cases testing the constitutionality of excluding women from jury service. It was not until 1994 in JEB versus Alabama, the Supreme Court handed out the decision that it is unconstitutional for gender to be a criteria in which the people who are screened for the jury selection process get held to. So now we're going to talk about women's relationship to military service. Citizenship has always been tied to military service in one way or another, dating back to the times of ancient Rome. During the Middle Ages, the idea that citizenship and military service are connected somewhat fell out of favor, but the idea was still somewhat present. And then the shift was then made to the idea that property ownership and blood connection is what defines a person's citizenship. So why not women? Well, it was believed that women are thought to put the security of their community at risk because they make their bodies available to please other persons. The demands of the state come second. This same rhetoric was also used to exclude male prostitutes from serving in the military. And then the second reason is that women owe their first obligations to their families, and then unmarried women to their fathers, married women to their husbands. So they could not possibly serve in the military because they had to deal with family matters. And then the third reason is that a lot of people are placing women into two categories. One is people who could complain about the price of war rather than placing value on the outcome. The second is that women were people who would criticize war solely on the means of setting ethical parameters for what men do in war. Both of these schools of thought did not do much for women besides further the notion that men are the defenders and women are to be protected. Just because the United States has never made any sort of like official policy that made military service an obligation for women, women have still been a part of the military for generations. During the time of early modern armies, it was common for civilians to travel with their troops. Civilians who travel with the armies did the cooking and cleaning for the soldiers, and these people were usually women. George Washington initially objected to a fixed quota of women traveling with the Continental Army, but nevertheless, women followed. Women have been participating in this type of work for the military for ages, but never got any sort of rank, title, pensions, or benefits. Sarah Osborne was one of these women who followed her husband to war. Osborne was delivering food to men on the battlefield at the Battle of Yorktown. After having encountered George Washington twice on the battlefield, at the age of 81, she was able to be compensated for her service. In 1837, Congress made it possible for dependent survivors of the Revolutionary War to claim veterans' pensions. Sarah Osborne testified to her husband's service as well as her own. Within her testimony, she revealed that she was at West Point during the brutal winter of 1780, rode on horseback into Philadelphia on the way to the Battle of Yorktown, and is on the battlefield during Siege of Yorktown. She reported telling George Washington that she believes she is a challenge to royal authority and that she would willingly hang for treason because of it. Another example of a woman in war was Deborah Sampson. Deborah is from Massachusetts, and she adorned men's clothing and took the name of Robert Shirtliff and enlisted in the 4th Massachusetts Regiment. She served with her regiment in New York under Captain George Webb's Company of Light Infantry. She was tasked with scouting for neutral territory and assessing British supplies. Her identity remained a secret for over 2 years with a few close calls. She became sick during an epidemic and was taken to a hospital in Philadelphia where she fell unconscious and her identity was discovered. Sampson received an honorable discharge in October of 1783 and then went home. Her life after the war was rather unusual for a woman of her time. She went on a year-long speaking tour in which she lectured about her experiences during the Revolutionary War. This makes her the first woman in America to accomplish such a feat of a speaking tour. In 1792, she successfully petitioned the Massachusetts state legislature for back pay for her service, making her one of the first women to receive a military pension. During the Civil War, many women cut their hair short into masculine styles and were able to blend in with younger army recruits. Many of these women could keep their identities a secret until they were wounded in battle. A handful of women also blurred the lines between soldier and camp aide. These women would cross-dress and act as spies, undress, and then go back to serving as cooks and laundresses. In World War II was the first time that women were able to receive permanent military status. Only white female nurses received equal pay allowances in full-time military rank. Black women were allowed to enlist, but only receiving the lowest grade positions in the Women's Army Corps and banned from enlisting in the Navy, Coast Guard, and Women's Air Service pilots altogether. In addition, Black nurses were only allowed to treat Black soldiers. By the end of World War II, 350,000 women, estimated to be about 4,000 of which were Black women, were involved in military service. The argument that supported women being able to serve in the military hindered on the argument of how valuable their service was to their men. This idea excluded women from active duty combat. In 1980, in the State of the Union address, President Jimmy Carter introduced a universal mandatory draft. This was met with a lot of backlash. A draft requires all men to sign up for it, proving that the subtext that citizenship was linked to manhood even in the 1980s. Some could not grasp the idea of training women to engage in violence. Many feminists at the time were firm in an anti-war, anti-draft stance as a whole. In March of 1980, the newsletter for Women's International League of Peace and Freedom had said, "We believe women are capable of doing the job, but the job is not worth doing." So now moving on to taxation. What does no taxation without representation mean for women? Abby Hassad and her sister Juliana Evelina Smith were 76 and 81 respectfully, and announced in person and in the press that they were not going to pay the highest property tax in their town until they gained the right to vote. Abby Smith used rhetoric that our country was founded on, that taxation without representation is wrong. Their test of the obligation to pay taxes lasted until 1876. The sisters were very politically active in their town, and especially for the abolitionist cause. It's important to note that many white women saw the liberation of slaves as one and the same as liberating themselves, under the notion that the same rhetoric applied to the equality of races and could be used to establish the equality of sexes. In the town that they lived, you had to pay taxes in order to speak at town meetings. This was designed so that those who paid taxes could debate one another on what the money they paid should be used for. However, women were not allowed to speak in the town meetings. This means that women were having to pay taxes but could not speak up for what they wanted the money to be used for. Abby Smith didn't care much for this rule and came to the town meeting on November 5th and gave a speech echoing the ideas of the American Revolution and implied that the slave owners in the South had a similar power that the men in the North used to rule over women. The very next day, the tax collector came by to see if the sisters had changed their mind about paying their taxes. They did not, and were still holding firm that they would not pay their tax until they could freely speak in town meetings. As a result, the tax collector said the town must take their cows to make up for lost tax revenue. They were not the only women to refuse to pay taxes. Lucy Stone, a popular suffragette, refused to pay the tax on her house because she was not adequately represented. The idea that women could refuse could not refuse to serve on juries since nobody asked them. Women could not refuse militia service, again, since nobody asked them. But women could refuse to pay taxes, and voting for representatives had been linked to paying taxes ever since tea was thrown in the Boston Harbor. So not paying taxes was something that women could refuse to do. This is a systemic issue. In the United States, the tax system is structured in the idea that it is combined with social traditions where wives are understood to be secondary earners. The idea that a father's work is inflexible and a mother's work is flexible is what keeps this system in place. And then where we're wrapping up for today, women were not completely free from their husband's authority until June 29th, 1992, when the opinion for Planned Parenthood of Southeastern Pennsylvania versus Casey was announced that American women were officially liberated from coverture. This marks the point in time when the Supreme Court officially stated that they would no longer recognize the power of husbands over the bodies of their wives. That's all I have for today. There's my email if you have any questions, want to talk more about this. But thank you for listening.
Thank you, Abigail. Are there any questions? Yes, Jovan first, then Tricia, then Skylar, then Julie. Boy, it lit up. No one ever asks questions like that when I'm talking. Jovan.
I was doing the clap reaction.
Oh, okay. I'm sorry. Oh, were those claps and not? Okay, good. No one ever claps when I'm talking either. This is good. What town were the Smith sisters in?
I think it was Gluttonsbury, I believe, in Connecticut.
In Connecticut. Okay. Good. Any other? Was there a difference between married women and single women under the law?
Yeah, initially, single women were still allowed to engage in contracts, file wills, that sort of thing, but married women were not. However, in the case of the town meeting, it was a ban on all women speaking, singled or married.
Mm-hmm. Okay, good. Now, I understood that in New Jersey, women with property could vote for a time after the revolution. Is that must have been very unusual?
That was really unusual. It wasn't, and then eventually that did get overturned. Like they wrote laws preventing it, but that was unusual for the time.
Okay. Other questions? Otherwise, it seems like I'm just grilling Abigail, who's done a really good job. Okay. Okay, well, thank you. Oh, yes, Jovan, now you have a question.
Towards the end, you mentioned women would resist not being able to vote, or I guess protest against it by not paying taxes. How effective was not paying taxes at, I guess, drumming up support for them? Like, how effective was it as a protest strategy?
In a lot of places, like there was after the Civil War for quite a while, there was no federal income tax. And a lot of times these women were either unmarried or widowed. So their property tax is very high. They were paying some of the highest property taxes out of people. So the town, city, state was losing quite a bit of revenue.
Thank you.
Haley?
Mine's just a comment. I was just going to say, I think you did an amazing job. You clearly put a lot of effort into this. So props to you.
Thank you.
Good. Okay. Well, thank you, Abigail. Well done. So where did we leave off last time when I was talking? I mean, not to get back to something really mundane like the Jefferson administration and what's going on there. Yes, Jovan.
The last thing I remember was people were concerned because Burr had made a private army and he said he wanted to conquer Mexico, but they thought he might be trying to do a rebellion. I think that was the last thing.
Okay. Anyone else remember more about this? It's an interesting episode, and I realize I should not use the word interesting since I may be the only one who finds it so. But here's yes, Paul.
I think also they were worried that Burr was going to go take over the western part of the country and the frontier and set up his own country over there.
Yeah, that's one of the suspicions, because Burr's talking to some people about raising an army, he's stockpiling weapons, and it's really unclear what it is he is doing. And just so you know, Burr had been vice president and then is cashiered essentially by Jefferson. So he's a political figure who has been cut loose. And he's also a man of great ambition, as well as great talent and great charisma. And so there is a certain fear about what Burr could do, particularly since Burr perceives that Jefferson is a pusillanimous weakling and that the Western country can't be held by the United States. You have Jefferson with this idea about, not having a strong central power. Well, what does keep the country together? And why wouldn't someone with a vision want to expand west and conceivably take over Mexico, as Javon was saying, but conceivably also, why not unite Mexico to the Mississippi River and create an empire there, and leave this kind of strange Republican ideas that Jefferson and his crew have, to their own devices. So that could be what Burr was doing, but it's unclear. And Secretary of State Madison gets these warnings from the governor of Kentucky saying, Burr's out here doing something, we're not quite sure what. And then the governor of Ohio saying, Burr's out here, we're not quite sure what. He's talking to these people about raising an army. And the first question is, what can be done about someone who seems to be plotting something that might lead to something bad? And Madison's initial response is, well, we really can't do anything. And then in early 1807, Burr, with this evidence compiled from various sources, one of the leading witnesses against Aaron Burr is James Wilkinson, who is a general and had been a general in charge of Louisiana. And Wilkinson is earning almost as much from the United States government, his salary as a general, as he is from the Spanish government, which is paying him to keep Wilkinson in the interests of Spain. And I'm not just saying this to make you think less of General Wilkinson. And if he testifies against Aaron Burr, you'll think, well, wait a minute, he probably was on the take from Burr to begin with, which he was. One reason Wilkinson seems to know a lot about what Burr was doing is Burr had been talking quite a bit to him. Burr talked to a lot of people. And on the evidence that General Wilkinson presents in early 1807, Aaron Burr is arrested in Mississippi and then brought back for trial. And, so here you have the former vice president. The news didn't travel as fast. There was no Twitter feed then telling people almost instantaneously what the vice president was up to. For all anyone knew, he had just decided to go seek other opportunities. He hadn't actually been canned by President Jefferson. And of course, Burr is a charismatic, interesting guy, which is something, of course, that the musical gets right. And here he is in Mississippi, and of course, he's very entertaining. Then suddenly he's arrested by federal marshals and brought back for trial. He's actually brought back in chains. When you're a federal prisoner, you usually are escorted that way. And the trial is going to be held in Richmond in the district court there. And the presiding judge will, of course, be the federal judge who presides over Virginia. And does anyone know what federal judge presides in Virginia? Thanks to the Judiciary Act of 1802, which made Supreme Court justices once again serve as circuit court judges. If you were writing a play, what character, what judge would you want presiding at Aaron Burr's trial? In the most high-profile trial of the century, the former vice president, now accused of treason and hauled back to be tried under the orders of the president, Thomas Jefferson. Yes, Trevor.
Either Marshall or Jay.
You would want John Marshall, yeah. I would think more than Jay. Jay, by this time, has retired from politics, and he's quietly at home writing treatises of biblical commentary. And so, yeah, John Marshall. So the guy who is the opposite of Jefferson. And so this is the only way it's going to work dramatically. Okay. And fortunately, for those of you who are now going to write a play about this, you'll have John Marshall presiding at the trial when what Jefferson wants most to happen is for Aaron Burr. By the way, did I tell you what the charge was? Why he had been arrested in Mississippi? I mean, you can't just go arrest someone because you think he might be up to something and drag him 1,000 miles in chains to stand trial. And it's probably not a misdemeanor or, petty theft. Yes, Jovan.
Well, you mentioned treason, so I guess
Yes, it is treason. It is treason. So Aaron Burr has been indicted for treason. Okay, now this suspicion that he was trying to separate off this territory from the United States and create this empire. Burr, of course, is claiming all he wanted to do was annex Mexico to the United States. And of course, he had told President Jefferson all about this before he left Washington. And if Jefferson weren't so obtuse, he probably would have understood. Of course, there are a lot of things the president might talk about that he doesn't write down. So Burr kind of understood that. And that's also the problem. Jefferson doesn't have a memorandum. Yeah, Aaron Burr came to see me and wants to annex Mexico to the United States. He's going to raise an army and I'm good with this. No, Jefferson doesn't really remember that Burr ever came to speak to him at all. Okay, so, but Burr is charged with treason. And treason is the only crime that is defined in the Constitution. So that's, sorry, my battery is running low. My computer's battery. My battery is fine. Okay. And what is the definition of treason according to the Constitution? It's in Article 3, Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. That's it. That's the definition of treason. Now, based on what I have just told you, Aaron Burr talking to guys about joining his army, stockpiling weapons. Is he levying war against the United States? Yes, Jovan.
I'd say no.
Okay.
If it has to be specifically against the United States, as far as I can tell, he hasn't made any overt declarations against them. Raising a militia on its own isn't treasonous.
Yeah, okay. And the militia actually hasn't done anything yet. Okay, so that's another thing. He is stockpiling weapons and doing these other things. And then it goes on. You're anticipating what else it says about this. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Wow, it really limits how you can get someone to confess to treason. And also overt act, that is an open act. So it's why do you think the Constitution is so specific about the meaning of treason? The definition of it. Yes, Jovan.
Because otherwise you can get into a situation where anyone who disagrees with you politically is like, well, you're committing treason, so off with your head, I guess.
Well, yeah, because the penalty for treason generally is death. Yeah. So you think this had been a way of getting rid of your political opponents. Yes, Paul, you had your hand up.
Yeah, I was just going to say the same thing. Basically, it just opens the door for people to be like, well, you disagree with our government regime politically, so we're just going to take insane action against you.
Yeah. Yeah, and it is a way, you think about, if you know anything about English history, you know how many people run afoul of the monarch, wind up in the Tower of London, get their heads cut off after kind of a sham inquisition against them. So for some reason, with our knowing that history, the framers of the Constitution wanted to prevent that. And so now you have President Jefferson having former Vice President Burr indicted for treason. And being tried before John Marshall. And of course, this raises a big question for those of us who are close readers of the text of the Constitution. Is Jefferson being a strict textualist here when he is having George Hay, the Solicitor General, prepare an indictment and trial of Aaron Burr? Has Burr committed an overt act that you can see? I did give you a nutshell of the trial, of what the case was or what Burr had been doing. Is there an overt act in all of that is levying war against the United States or giving aid and comfort to the enemies of the United States? Raising an army here, stockpiling weapons there, talking to this group about possibly doing something. Those are actually three different acts. The Jefferson administration argues that all of them together are constructive treason. That is, they are all the steps to treason. And how do you suppose Chief Justice Marshall will rule on this? Marshall is less of a strict constructionist than Jefferson is. And in his Marbury decision, he kind of saw and in 1818, he's going to come out and say, yeah, the bank actually is constitutional using Hamilton's reasoning. But in this case, John Marshall is a strict constructionist. Aaron Burr has not committed an overt act of treason. And you can't find two witnesses to the same act he has done. And so it is one of the most important trials in the history of the country, because we can easily see, had it gone another way and Burr is hanged for treason, or maybe he's pardoned and sent off into exile, that would pretty much be what happened every time there's a change of administration. You go after whoever was in the last one to get rid of them, or some pesky person who's criticizing you. You find that they are guilty of treason. But here we have two things. One, the Constitution very clearly defining it, and then B, the Chief Justice being very strict in interpreting what the Constitution means. And had Aaron Burr given aid and comfort to enemies of the United States? Well, no. And so another thing that comes up during the course of the trial, and this is also important for things aside from treason, Aaron Burr maintained that President Jefferson knew all along what he was trying to do, that Burr had told him about it before Burr left Washington. And how would you find out if you are Aaron Burr or you're Aaron Burr's defense or you are the court, whether or not Thomas Jefferson knew what Burr was doing? Let's suppose Trevor is on trial, and Trevor maintains that I knew all about what he was doing, and therefore I should come to court to testify as to what I know. Right now, it's just Trevor telling the court, oh yeah, Professor Allison knows all about this. Can the court do anything so that I would provide verification for Trevor or contradict? Yes, Jovan.
They can subpoena you. They can do subpoena Ducas Tecum, see if you have any documents attesting to that fact.
Yeah, subpoena, the Latin Jovan was going to tell us for under penalty, that Jefferson doesn't say, hey, yeah, I can come and clear this all up. He hadn't, by the way, Jefferson is very much interested in this case. He is almost constantly writing to the prosecutor, but then when Burr suggests and the Chief Justice Marshall suggests possibly subpoenaing President Jefferson to get him to come to Richmond to testify, what do you suppose President Jefferson will do? Should Jefferson go and testify in Burr's trial? Yes, Jovan.
I'd imagine Jefferson would say something like, can't subpoena the president because it's like a direct action of one branch against another outside of the Constitution or something like that. So, and I also imagine he wouldn't want to go, especially not in support of Burr.
Yeah,
he's not doing this against him.
Yeah. So first and foremost, Jefferson is not going to want to go. Okay. And secondly, remember, Jefferson is probably one of the best lawyers in the country. He understands the law. And possibly the only better lawyer than Jefferson at this moment is John Marshall. Both of them studied under the same law teacher, George Wythe, in Virginia, and Jefferson was a great student of the law. And he doesn't actually get a subpoena. He reads in the newspaper that Chief Justice Marshall is considering issuing a subpoena against President Jefferson to compel his testimony in the case of the United States versus Aaron Burr. And Jefferson's response is that the president cannot be subpoenaed because the president, for a couple of reasons. Most importantly, the president is responsible in this case for 3 million people. And here he has someone saying that the president's testimony would be really useful to one person in Richmond, and then the president would have to leave his post where he is responsible for the lives of 3 million people to go attend to this one. And then what would happen is someone in Maine would say the president's testimony would be useful in my case. Then someone in New Orleans would say his testimony will be useful in my case. And the president would spend his entire administration going from one courthouse to the next. It's a reasonable argument. And he also says that the Chief Justice under the law is responsible to the sheriff of Henrico County, Virginia, to serve on a posse. But if the sheriff calls him to do posse duty, that would be taking him away from his bigger obligations as Chief Justice. And Jefferson says the president shouldn't do this because it's a distraction. Also, he does bring up an argument that Jovan mentions about the executive does have defenses against the other branches that are stronger than what the other branches have. That is, the branches are supposed to be separate. And if the president is subject to subpoena from the judicial branch, he is, in fact, under their jurisdiction when the Constitution indicates by the fact that the executive has more power to defend itself. That's not what the framers of the Constitution imagined. Very sophisticated argument Jefferson makes about presidents not having to answer subpoenas. And it essentially becomes the argument. And by the way, anytime a president is being threatened with a subpoena, it's not a good thing for the president. This comes up in a big way, actually in the most dramatic way in the 1970s during the Watergate crisis. And President Nixon argued that he did not have to respond to a subpoena because President Jefferson hadn't. And by the way, if you're a Republican like Nixon at that time, the best thing you could cite was a Democrat like Thomas Jefferson. Thomas Jefferson at that time was still the archangel of the Democratic Party. And but Nixon, I think, had a point. And then Congress tried to clarify this in a series of laws passed in the wake of Nixon's resignation and Special Prosecutor Act and so on. And then actually in the 1990s, when President Clinton was accused of various acts of sexual misconduct before he was president, and there was actually a civil lawsuit going forward filed by a woman in Arkansas. And the Supreme Court in that case ruled that her case could go forward while Clinton was president. And thus he did have to respond to a subpoena in that case. I think it was a mistake on the part of the Supreme Court because a longstanding idea was presidents don't have to respond to subpoenas while they are in office, and they can't actually be tried for charged with something while they are in office. So anyway, I thought it was a mistake. Maybe it was a good idea. It's going to be up to you folks to sort it out over the next. No, I don't think there ever will be a president who does anything wrong while he or she is in office or before he or she is in office ever again. We've solved the problem of electing bad people. And so that's essentially where things are. But Jefferson responds to the Solicitor General saying he's not going to respond to a subpoena because he's the president, not that he's above the law, but because his duties compel him to be attendant to other people's responsibilities. So that's the big constitutional issue. The other big constitutional issue is what is treason? And the court in this case rejects the administration's idea of constructive treason, that you have all of these things leading up to treason and that's good enough. No, the court says the Constitution is very clear. An overt act two witnesses to the same overt act, levying war against the United States or giving aid and comfort to their enemies. And Aaron Burr is acquitted, which is a good thing, I think. Okay, I should preface things by saying what I think rather than just telling you it's a good thing, and then you'll go forward saying, yeah, Aaron Burr tried to destroy the country, but Professor Ellison says it's a good thing he got off. Any questions on this, or anyone want to come out in condemnation of Aaron Burr? Okay. Another thing is happening while the Burr trial is going on, and that is this. The United States Chesapeake is on its way to the Mediterranean. It's, the United States is patrolling the Mediterranean, and off of the coast of Virginia, the British warship Leopard stops the Chesapeake because the Leopard and the British Navy maintain that there are aboard the Chesapeake a number of deserters from His Majesty's service. And this is a period, by the way, before people carried passports and photo IDs and other things. And so the thinking is there are a number of people aboard this vessel, that is American sailors, who actually are deserters from the British Navy. And the Chesapeake was not prepared for any action. In fact, they weren't expecting any hostilities before they reached the Mediterranean. And so they still had a lot of luggage piled up on top of the various guns. And by the way, if you are the captain of the Chesapeake, what should you do when a British ship just off the coast of the United States demands that you stop? Yes, Jovan.
Probably turn around and go back to the United States, where presumably they won't pursue you.
Okay. Well, here's the thing. Do you know how a ship tells another ship to stop?
I would think they raise a flag or something, or maybe fire a warning shot.
They fire a warning shot across your bow, signal to stop. Yeah, there is a warning flag too, but that's it. A shot across the bow. Okay, so they've already shot, telling you to stop. If now, and say turn the ship around, that sounds a lot easier than it is. It requires you to send men up into the rigging and have bring the ship about, and it depends on which way the wind is going. And there's also kind of a dispute about who is in charge of this ship. They have a commodore in the person of James Barron, and then they have a captain, and these two guys didn't really get along. And the ship, by the way, one reason the ship hadn't even been able to fire its traditionals. It had left Washington under the command of a captain, and it hadn't been prepared enough even to fire the traditional salute when it passed Mount Vernon. Gets to Norfolk, picks up Commander Barron, and also when it's at the dock at Norfolk, the ship at the next dock was the Leopard. And this is how the captain of the Leopard knows there may be British deserters aboard this ship. And so then he follows it. He goes out and waits for it. And as I said, the Chesapeake's not ready to fire a gun. And then the British do fire a warning shot. They really can't turn around. And I think there was probably a delay like this where people are wondering, what should we do? Lieutenant Suarez says, let's turn around. And anyone else have any ideas what we should do? See, we're all befuddled. We hadn't really thought this was going to happen. We've just left port. We haven't even unloaded all of our bags that are piled on top of the guns. One lieutenant actually does go below deck, and he gets a coal out of the stove, and he goes to one of the guns. He does this after the thing I'm about to tell you happens. The British, waiting for the Americans to stop, realize maybe they're not going to stop and fire a broadside, which kills about 3 or 4 sailors. I mean, the Americans had not been anticipating having a broadside fired at them. And then Lieutenant Allen goes below gets a coal out of the stove, gets one of the guns loaded and fires back. But as he is doing this, Commodore Barron up on the deck is ordering the American flag lowered and a white flag run up. Okay, we're going to stop. We're not even going to try to turn around. And then the British send a party aboard, and Barron tries to deliver the entire ship to him. And he says, no, I don't want the ship. I just want you to muster the crew, bring them up onto the deck so I can pick out the deserters. So the 300 or 400 men who are the crew of the Chesapeake are brought up to the deck, and the British officers go down their lines and they pick out 5 men that they say are deserters from His Majesty's Navy. And they take these men back to the Leopard and then tell the Chesapeake, go about your business. What would you do if you are Commodore Barron? What's your business now? Well, yes, Jovan.
I think you either keep going and just pretend it didn't happen, or you go back to your state, say, hey, the British just attacked us.
Yeah, I
Need help.
I like that idea. Pretend it didn't happen. I mean, the ship's actually been damaged in this broadside, okay? And you've had men killed. And so he does go back to Norfolk to get the ship fitted out again. And also he has to send a report of this to Washington. Can't say it did, not a big deal. Is it a big deal when the British fire a broadside at an American ship just off the American coast and take men off of the ship into the British service? Is that something, Jovan's ready to pretend maybe that didn't happen. Maybe I was imagining that. Is that a big deal? Haley's nodding. Yeah, it's a big deal. Haley's incensed. Haley's whatever Abigail said about women not serving. I give a sense Haley's on her way down to a recruiting station now to do something about this. And but by the way, Barron makes a critical error when he does get back to Norfolk. To the person he assigns to carry the message to Washington is an officer named Nicholson. And young Mr. Nicholson is the nephew of Albert Gallatin, who is the Secretary of the Treasury. And maybe Barron thought, good, he'll get the administration on my side. Probably not a good idea for Barron's overall career to have this guy ready to say, really was Barron was at fault. It's not clear that Barron was completely at fault. He hadn't been in charge of the ship when it left Washington. That's a story for another day. Okay, so anyway, the administration realizes this is a huge problem now. You've just had this American warship attacked off the American coast by the British. And what can you do? What should the United States do? Anyone other than Paul or Jovan have a suggestion now for the Jefferson administration to prevent the British from attacking your warships off of the American coast? What kind of options do we have? I guess pretend it didn't happen would be one thing. Maybe that's what everyone but Haley wants. And yes, Matt.
So the options are either he can pursue a diplomatic recourse with the British to de-escalate the tensions, or he can give in to the calls who were calling for war.
Okay. Ask the British really nicely, and maybe they won't do this again. Yes, Haley.
I would say try to talk with the British and figure out why it happened in the first place to make sure that it doesn't happen again.
Okay. Well, good. I think we know why it happened Jefferson's administration knows why it happened in the first place. The British and the French are at war. The Americans are trading with both the British and the French, maintaining we're neutrals. Okay. This is the big story here. And the British had said, if you're trading with our enemies, you can't trade with us. And furthermore, we'll stop merchant ships that are trading with France. The French have said the same thing. The French at this time control the European continent. The British pretty much control the seas. And the United States has been trying to be neutral between the two. And because the British control the seas, they need a big naval force. And in order to maintain the naval force, they need a lot of sailors. And if you're a British sailor, you are going to seek any way you can to get out of the British Navy at this time. You're not doing this for God and country. You're doing it because you've been forced into this. And there's a big mutiny in 1798 in the British fleet. And the reason why they thought there were British deserters on the Chesapeake was the Leopard had been tied up next to it for a while. And they know that British sailors have gotten off and gotten onto the Chesapeake. Some British captains maintain that about a third of the American sailors actually are deserters from the British Navy. It's the only way the Americans, they think, can maintain such a navy is by getting British deserters aboard. So the British maintain we did this because you're harboring deserters from our fleet. And also you're trading with the French, who are our enemy. We're fighting against Napoleon and you are trading with Napoleon. The Americans say, well, we're also trading with you. And that's, I guess, a story for a different story. Anyway, Jefferson's, we kind of know from the British why this happened. And the possible responses are a little bit limited. If, as Matthew was saying, maybe we should declare war on England, you also have to look at, pretty sobering statistic that the British Navy has about 1,000 ships in its fleet, and the Americans have about a dozen. And it takes a while to build these ships. Also remember, the Jefferson administration is committed to economy. So it hadn't wanted to build more ships. Yes, V, you have some thoughts on this.
Well, what I was reading was Jefferson's safe solution was to stop trade, stop allowing all British ships to come into American ports. And because you would get ready to say that the economy was a major priority, stop all trade between everybody, between Europe and all Europeans, and because they need American trade to go back and forth, that actually will hurt them because they can't come to port and they can't get American trade.
Right. Yeah. So Jefferson and the Republicans have a brilliant idea. That is, we know that wars are the result of corrupt political powers which get into wars as a way of enriching themselves. And here you have the British monarchy and the French Empire, who have created this huge war to aggrandize themselves. And Jefferson is going to show that the United States doesn't play this particular game. According to Jefferson's political philosophy, both Britain and France rely on American grain to feed their army and navy, as well as their civilian population. And if we cut off their supply of American grain, the people who are now subjugated by Napoleon's armies will starve. They will rise up in rebellion and overthrow the empire. And if the British people are cut off from the grain being provided by the Americans, they will rise up and overthrow the monarchy. And thus you will have Republican institutions in both the European continent and the British Isles doing away with monarchies, and you will have these good Republican states which won't go to war. So what Jefferson and the Republicans will do is show the power of American trade. One idea is, we build 1,000 ships to fight the British. Well, that's hugely expensive, and it would take us, probably about a decade or more to do that. Or we go to war with what we have, which is going to mean devastation to our coasts and to these ships. Every merchant ship we have is going to be sunk by the British Navy or by the French. So instead of that, we will cut off the lifeline to Europe, the trade they depend on, the grain that feeds the people in Europe, the fish that feeds the labor force in the West Indies. And the people will come to their senses as they are being pushed to starvation and throw off these corrupt regimes that are oppressing them. it's a wonderful idea about trade as a weapon that will change the world. It's a lesson that Jefferson is going to give to the rest of the world about the better way to solve disputes than having a few warships go and shell somebody, or having a huge army that goes to invade Austria or Russia or one of these other places the Napoleon's armies are invading. Well, Italy first. I mean, anyone with any sense would go to the warmer climes of Italy before you try to tackle Russia. So you have Jefferson's idea. It's not just a way to protect American commerce. It's a way to spread the idea of liberty through the world. So in the wake of the attack on the Chesapeake in 1807, in December of 1807, Congress proposes an embargo on American trade. That is, no ships will be allowed to enter or leave American ports, as a way of cutting off the supplies to the belligerent powers, bringing them to their senses, possibly. If they don't come to their senses, then the people who are being oppressed under these regimes will overthrow them, and you will have a peaceful millennium ushered in, thanks to the wise statecraft of Thomas Jefferson. I see some people have shut off their cameras completely. Others of you are now enraptured, as I am, with this prospect of the peaceful world in which we have now lived for 200 years, thanks to the wisdom of President Jefferson and his administration, which didn't fall for the bait the British are dangling with the Chesapeake and the Leopard, but instead showed a Republican alternative to war. Can I hear an amen? That yes, we did it. By the way, yes, V.
Oh yes, well yes, it was at the moment it was a peaceful resolution because um Europe did rely heavily on the United States for the trading, not only just between uh, Virginia. They also, up and down the whole sea coast, and now eventually going into Louisiana and possibly moving out west, as well as, they have trades with the West Indies and all that good stuff. But then on the other hand, um, even though you're cutting off Europe, in a way you're spiting America's nose as well, because now Americans can't get rid of their products.
Oh, that's right. I mean, Boston Harbor now is filled with ships that can't go anywhere and stuff that can't go anywhere. And if you are a merchant, you might ask, what gives the government of the United States the power essentially to end all trade? By the way, is this something that's in keeping with a limited idea of federal power? Yeah, Matt's now shaking his head. Paul Shea, Giovan's shaking his head. Yeah, the old adherents to limited government now are shaking their heads at this. And by the way, a couple of cases do come before courts. One in Massachusetts, of course, a merchant sues saying the federal government has restricted trade, and what gives them the power to stop it. And a federal judge, actually a federal judge appointed by President Adams, says, yes, the federal government does have this power. And the Congress has the power to regulate trade. And in South Carolina, a federal judge appointed by President Jefferson says, no, the federal government doesn't have this power. And so you have a kind of a disagreement about the constitutionality of this. At the same time, there's also the political disagreement about it. Does the embargo work, or is it an effective tool? Jefferson's argument was, well, the federal government could also declare a war. And if there is a war, that's going to destroy more ships and more property than an embargo. It's a Republican alternative to war. The sad news for the idealists among you is that it doesn't work. It turns out the British and the French don't depend on American grain as much as the Jefferson administration thought that they did. And what does happen is American merchants, and remember, the tariff was the source of 95% of American revenue, simply ends because nothing's being traded. So the federal government doesn't have any revenue, and the embargo doesn't work. And in some places close to the border, you do find people taking their boats, say, across Lake Erie or Lake Ontario to Canada to provide with the British there. And the governor of Massachusetts, you're able to engage in the coasting trade. That is, bring a cargo from Boston to Charleston, South Carolina, or to New York. Turns out there's a lot of wheat now going officially to Charleston, South Carolina. Of course, once it's beyond the coast of the United States, they head straight east toward Europe. It turns out there's a lot of subterfuge going on in this. So the embargo is, we don't know about there is going to be a war with Britain anyway in a couple of years. We're hoping this will stop that in its tracks. It turns out not to work, but we'll leave the Jefferson administration with that. We'll discuss this more on Thursday. I'll send you some documents to look at. So hopefully we can talk about this and you're not just listening to me explaining it all to you and making you feel either better or worse for President Jefferson and whether the Constitution has been secured. Anyway, I will see you on Thursday or Wednesday. I'm sorry, Wednesday. Yes.
Thank you.
Okay, Professor.
Take care.
Thank you, Professor.
Good to see you, Haley. Take care.
Professor?
Yes, Ekman.